If your dog ever bites someone, you might end up in a courtroom. Not your dog, you, as the owner, facing a fine or a lawsuit. For roughly 800 years in Europe, that split didn't exist. If an animal killed someone, destroyed crops, or, and this actually happened, laid a suspicious egg, the animal itself was arrested, assigned a defense lawyer, and put on trial, exactly like a human defendant. Not folklore, not village superstition. Real courts, real judges, real verdicts, including in one case a public execution for witchcraft. What that entire legal system actually believed about animals and why it eventually stopped says more about how law works than you'd expect. The scale of this is the first surprise. The definitive account comes from Edward Payson Evans, an American scholar who taught at the University of Michigan before turning to European legal history. His 1906 book, The Criminal Prosecution and Capital Punishment of Animals, catalogued roughly 200 documented cases stretching from the 10th century to the 18th. More than 100 of those took place in France alone. The defendants included cows, horses, dogs, and in 34 separate recorded cases, pigs specifically, common enough as repeat offenders to form their own pattern in the record. This wasn't a handful of isolated incidents. It was a functioning, centuries-long legal category. The most detailed surviving case shows exactly how seriously courts took it. In December 1457, in the French village of Savigny, a sow attacked and killed a 5-year-old boy. The sow and her 6 piglets were arrested and jailed alongside their owner, Jehan Bailey, a month later. The case went to trial before the local judge, with 3 lawyers involved, 2 for the prosecution and 1 representing the pigs, and 9 named witnesses giving testimony. The judge ruled that responsibility for the killing belonged to the sow specifically, and sentenced her to be hanged by her hind legs from a tree. Her piglets, though, were acquitted. The court found no direct evidence they had participated, and let them go on the legal equivalent of a promise of future good behavior. That's not mob justice. That's a court weighing evidence and issuing separate verdicts for separate defendants, one of whom happened to be a piglet. Pigs and cattle went to secular courts like this one. Smaller creatures went somewhere stranger. In 1522, the town of Autun brought charges against its rats for destroying the region's barley harvest. But rats couldn't be tried in a normal court because vermin fell under church jurisdiction, not civil law. The bishop's court appointed a young lawyer named Bartholomew de Chassigny to defend them. When his clients failed to appear for their summons, Chassigny argued this wasn't contempt of court. His clients were scattered across many villages, and traveling to the trial meant crossing territory patrolled by every cat in the region, putting their lives at a genuine risk. The court agreed and ordered the summons reread from the pulpit of every parish where the rats might live. Chassigny's defense became well known enough to help launch his career. He went on to become one of the most respected jurists in 16th century France, and in 1531 published a legal text specifically on the excommunication of insects and vermin. The strategy in both kinds of court was different, but the underlying logic was the same. Animals could be held legally responsible. They just needed to be prosecuted through whichever branch of law actually had jurisdiction over them. And jurisdiction wasn't the only strange thing about how these trials worked. Pigs and rats were prosecuted for things they had actually done, killing, destroying crops, but some trials weren't about physical harm at all. In August 1474, in Basel, Switzerland, a rooster was put on trial for laying an egg. Under the folklore of the time, an egg laid by a rooster was believed capable of hatching into a basilisk, or cockatrice, a serpent-tailed monster that could kill with a single glance, and was also prized as an ingredient in witches' ointments. The court didn't treat this as a joke. It appointed a prosecutor and a defense attorney. The prosecutor argued the rooster was a minion of Satan. The defense argued the egg was simply an unusual but natural occurrence. The judge disagreed, found the rooster guilty of witchcraft, and had it burned in the public square in front of a large crowd. This wasn't really a trial about a chicken. It was a trial about what people were afraid an egg might become, which meant the rooster was being punished for something that hadn't even happened yet. So what happened to make all of this stop? By the late 1700s, animal trials had almost entirely disappeared from European courts, and the reason wasn't a single ruling, it was a slow shift in what lawyers meant by guilt itself. Enlightenment-era legal philosophy increasingly tied criminal responsibility to something called mens rea, a guilty mind, the capacity to understand your actions and choose them anyway. Animals, the new consensus held, couldn't form intent the way a human defendant could, which meant putting one on trial wasn't really justice, it was theater. The formal apparatus of a trial, a hearing, a judge, evidence, a ruling, didn't disappear, though. It just changed what it was for. Walk into most U.S. states today and you'll find dangerous dog statutes that still require a formal hearing before a judge can order an animal euthanized. Virginia and New York both spell out the exact evidentiary standard, and owners still have the right to appeal. The dog isn't the defendant anymore, but the ritual survived a theory that used to justify it. So, think about what that actually means. For 800 years, otherwise sophisticated legal systems were completely certain that animals belonged in a courtroom, right up until they weren't certain of that at all. What in our own legal system right now feels just as obviously correct, in a way some future court might find just as strange? The pigs, the rats, and one deeply unlucky rooster weren't being judged by fools. They were being judged by a system as confident in its own logic as ours is today. That confidence was the only thing that changed.